Welcome to Chat with the Lawyer, and I'm your host, Walla Blagay. And today we have a special guest, Camille Stewart, who is an intellectual property and internet lawyer. And she's going to give us advice today about protecting your brand. So we are going to have fun today. So small business owners, please listen up. Very important information. So Camille, tell us a little bit about your practice.
Well, Walla, I work for a world-leading cybersecurity company by day, and I manage the intellectual property portfolios for Fortune 500 companies. So it is my passion to make that accessible for the individual and the entrepreneur. So through my blog, thedigitalcounselor.com, my consultancy, Mark Law, and the workshops that I give around the area, I try to make sure that that information gets to the masses.
Wow, so how does she sleep at night? All the good stuff you do. Well, let's get into it. So let's just say I am starting an event planning company, and I'm naming it Shades of Red Company, and I got a great logo. I've got a friend that put together this wonderful logo, and now I'm going to start my website. What are some of the things that I should be thinking of putting this logo together? Walk us through it.
So anytime you invest in a company, a blog, a brand of any sort, you want to make sure that you protect your intellectual property, which is all the creative stuff that you've done, right? So that company name, the logo, all of that is yours, and you want to make sure that you protect your revenue stream. So it's important to secure trademarks for the brands and the logo. It's important to copyright your website, make sure that the content is on display and people know that it belongs to you. And you also, if you so happen to have any inventions or anything, get some patents behind that as well. But you just want to make sure that you're protecting all of your creative materials and putting people on notice that you know that you own it.
So now describe the trademark area. So what do you mean by protecting my trademark? What should I do?
So a trademark is what we would call a brand identifier. It tells people everything they need to know about the mark. Trademark law was designed to protect the consumer. So when they hear a brand such as Pepsi, it tells them about the color of the can, it tells them the quality of the product, it tells them about the taste, it tells them a whole host of different things about that specific product. And that's what you want your trademark to do. When people hear Shades of Red, for example, you want them to know the quality of that event planning business, you want them to know location, and what other the details that you decide are associated with that trademark. So you can gain common law trademark rights just by using it in interstate commerce, which could be posting your website on the web or doing an event that crosses state lines or making some kind of transaction with a vendor across state lines.
So are you saying if I decide I just want to do it Shades of Red in Maryland and I'm not necessarily going to post a website, but maybe I'm going to print things out and pass it out around, am I not in the...
So you will likely enter interstate commerce by that. Your first sale is going to be considered interstate commerce. However, that will only afford you common law rights. You want federal rights because you don't want someone, even if you are going to operate just in Maryland, to open that same business in DC or Virginia or any other area for that matter. You want to make sure that you have broad spectrum protection. Common law rights only give you a small measure of protection.
Now, define now, for the regular person, what is common law? Explain that.
So common law is kind of statewide rights, okay, right? So you want them nationwide, federal. You want to go to the PTO and file an application.
What's the PTO?
Yeah. The PTO is the United States Patent and Trademark Office. So you want to get a lawyer to do that for you because that process can be a bit arduous and confusing, and you just want to make sure that it's done right the first time so you don't waste any money or time. But getting those rights will make sure that nobody else can use Shades of Red or anything like it.
Interesting. So what about a picture that I put with it, a part of it? When I'm signing up at the trademark office, is that something that they consider? Do I send in the picture of the logo? Is that what I'm...
So there are two types of marks that you can file. A general mark, which is a word mark that just has the words, or you can file a design mark, which would include your logo. It is always my recommendation that you go for the word mark because it will protect that mark no matter how you write it. If you write it plain hand, if you have it in a logo, if you print it on a piece of paper, it will be protected. If you do a design mark, which just has your logo, you're only protecting the logo. So it has to appear in that exact same form. Now, trademarking a logo is a lot easier than trademarking just the word, but it affords a lot more protection. Now, if you have a bigger budget, I would suggest you do both. But if you are limited in your budget and you can file one trademark application, always file the word mark.
Okay, and you do that before you post the website, or can you do it?
So you can do it at any point. I recommend that the sooner the better, but you have to consider the distinctiveness of the mark. So there's a distinctiveness scale of about five different levels.
Okay.
So if the mark is fanciful, it will automatically get trademarked. And so fanciful would be something that you made up, a word that has no real meaning, it's never been heard before, like a Kodak or a Xerox, right? Then there is a arbitrary mark. So that is a word that's real, but not at all associated with the thing that you're producing or the service that you're providing. So a great example of that is Apple. Apple is a real word, but it has nothing to do with computers. Then there are suggestive marks, which will also be trademarked very easily. And they are kind of words that you either piece together or somehow slightly indicate what's going on, but aren't a complete description of what's going on. So a great example of that is Microsoft. You know, micro kind of reminds you of microchips and software. So you kind of feel like it's in that computer software family, but it doesn't directly say computer. And then you get into descriptive marks, and that's where you get into an iffy area, because merely descriptive marks, so if you were trying to put out a brand of facial tissue and you tried to name it facial tissue, that's descriptive. But if you put out a mark that is descriptive, but you can prove that it's acquired secondary meaning, meaning that despite the fact that it kind of describes what's going on, people know that that's associated with you. Then that is something that you could get trademarked, but you'd have to prove that, and trademarking that would be a bit difficult, but you can make it happen. And then there are generic marks, and if it's generic, you will not get it trademarked. So that's kind of like if you tried to trademark the word salt for sodium, you know? So you have to find out where your mark falls on that spectrum and be prepared to make those arguments that it falls within whatever category. So shades of red is a great one because it doesn't indicate that it's event planning. So it would, yeah, exactly. So it would kind of fall in that arbitrary range, and you'd probably have a pretty easy time trademarking that.
Now let's hop into the risk. Now, what is the risk of not trademarking at the time you put the website up? But name some of the risks that can happen. Some people put up a website, they say, look, I don't want to spend the money right now. I need to just get this website up so I can get my business going. That
is definitely something you can do. You can kind of do it simultaneously, right? It's actually probably easier to do it simultaneously depending on what you've been doing in the background. Because like I said, you need to use it in interstate commerce. So if you don't have the website up and you haven't made any sales or anything like that, then you would need to wait. But the things that you need to be worried about are other people using your mark, especially in the internet age where social media is prevalent and people tend to find things online and use them. Oh, that's a great idea. I'm just going to kind of take it. You want to make sure that your investment is protected, and you want to make sure consumers don't get confused. And very often, bigger brands take little brands, right? So you've come up with something amazing, and there's a bigger brand that could use that. If they use it and get it out there more than you can, they can secure that trademark before you, and then you would have to stop using it. And that's the last thing any of us want.
That is interesting, Barry. Now, you have clients that do a lot of blogging, right? And so talk about the advice that you give to them in their blogging and internet.
So a lot of people kind of diminish the value of a blog, right? Because there's so many out there. But blogs can be monetized. It is extremely important that you consider trademarking the brand of your blog, especially if you feel like it could have a broad reach. So you want to trademark your name, and if you have the budget, trademark the tagline. And trademarks are in categories, so you trademark in the area in which you're operating. If you have the budget, also trademark in merchandising if you think it could be big. And then also, very importantly, and something you can do right away and yourself, is make sure you put people on notice that you have copyrighted your materials. So every post should have the copyright symbol, the year, and then your name or the name of whatever company you're operating under at the bottom of every single page. The nice thing about copyright protections is you do not have to secure a federal registration for it to be valid. You just need to publish it. So whether that's posting a new blog or putting out some kind of content on your website, that is copyrighted, and you want to put people on notice by using the symbol, the year, and your name or the owner. And then if you do something bigger, like if you turn that blog into a book, or you have some kind of photography display or something like that, you produce music, you want to make sure that you've registered that with the Copyright Office. That's the point where you would take it to that next level and make sure that it's in Library of Congress. Because when you federally register something, it is on record forever in the Library of Congress.
That's interesting. Now, describe now when you put the copyright next to your sign, don't you have to do something, but you just put that up? You don't need to do anything?
You don't need to do anything else. That is the amazing thing about copyright protection, is that once you put that notice up, I mean, honestly, you don't even need the notice. Once you publish it, you have secured copyright protection. But putting that notice up lets other people know. It also gives you kind of a date stamp, even though the great thing about the internet is a lot of things have date and time stamps. But it kind of tells people, I've been using this since this amount of time, and just kind of legitimizes your claim about your copyrights.
Now, for date, you said you put the date. Do I put, because I just see copyright, usually see like a year.
Yes, that's all you need to put.
You don't need to put August 28, 2012?
Right, exactly. Don't put that. I would just recommend putting the year.
Okay. Yeah. All right. Well, that's interesting. So what are some of the other things that your clients are interested in that you have to advise them about? Okay, walk us through some of the other things.
So once you secure these protections, it is your job to police them. And so what that means is the government gives you these protections when you've applied for them and they're rightly acquired. But they don't go out and find people infringing on them. Mm-hmm. So it is your job to look for people who are using your trademark illegally, using your copyrighted materials illegally, using your patents, things like that. So you need to use, there are a lot of websites. You can set up Google alerts for all of these things. You can use all kinds of different things to find people, using your content. And then make sure you're going after them. So that can start on the level of a cease and desist letter that I recommend that you draft with an attorney, but then you can kind of take action on those by yourself and then escalate as necessary. But after that point, I would definitely consult with a lawyer, because you want to make sure that as you progress, you're considering all of your options. It's very important to make sure that you are preparing yourself for trial, if that so needs to be the direction that you're going. So you don't want to do anything to kind of harm your case later.
So you send your cease and desist letter. How long do you wait before litigation?
So what I usually do is I send in 3 rounds. So you send a nice cease and desist letter that's like, please take this down. I think you've used this in error. Mm-hmm. And then you kind of escalate it from there. And I usually use 1-week increments. Mm-hmm. After that, depending on where the infringement is, there are a couple different avenues you should go. So if it's copyrighted material, you want to use the Dmca, which is the Digital Millennium Copyright Act. And every website must accept notices of people infringing on their claims using the Digital Millennium Copyright Act. And so there are a couple things that you have to include in that notice, but you send it to your Facebooks, your Twitters, your whoever, and if it's legitimate, they have to take that content down.
So this is to like GoDaddy.com, this internet site?
Right, so it could be any online service provider. So that's anything from your social media networks to something bigger like a GoDaddy or a GitHub or anything like that. Okay. So that's one avenue, and then you wouldn't even have to go to trial, which is awesome. If it's in your domain, so somebody uses shadesofred.com, and that should be yours, right? You can, exactly. Domains are so important these days. So you can use the Anti-Cyber Squatting Act to get that information down and reacquire those rights by reaching out to the host provider. But with trademarks, eventually, if people will not take that information down, you do have to escalate to trial. And that's really a decision you make with your attorney. But if those cease and desist letters aren't working, and if it's something that could be harmful to your brand, that's when you want to go to trial.
Okay. Now, let's talk a little bit about using somebody else's brand and the risk of that. In Maryland, what happened, there was a state senator that used, his last name was Hershey, and he used the Hershey signs with sort of, hinting towards Hershey chocolate as his campaign signs, and Hershey came after him. So, looking at something like that, that is a risk that, many of us take in trying to make sure if we use something that's popular, well-known, maybe it might get me more business.
Right.
So just quickly touch into that of what some of the problems with that.
So, like the senator, although he is a public figure and you would think he'd get a little more leeway, if it doesn't fit with the Hershey brand, they're going to come after you. So you want to be careful anytime you use anyone else's brand, because they have the rights to come after you. And even if it's not harmful, they will likely do so in an effort to make sure that their messaging is consistent, which is also something you should be worried about as a brand owner yourself. So as you seek to use these things, one, make sure you're giving credit to these people. And two, seek permission if possible.
Okay, so reach out to, so what if, let's just say the Pepsi using the Pepsi swirl on the top and bottom and maybe putting shades of gray in the middle, shades of red in the middle.
Definitely reach out to Pepsi for that. You are likely to get a no.
Well, this has been fun. We're going to take a short break and we'll be back talking about protecting your brand. Welcome back to Chat with the Lawyer. I'm your host, Walla Blagay, and we're here talking with Camille Stewart about protecting your brand. Now, we had a lot of fun on the first half talking about what we should do to protect our brand, and my brand today was Shades of Red, my event planning company. So we're going to continue with our consultation, and Camille, tell us about the various intellectual property rights.
Sure, so there are actually a handful. Most people are aware of trademarks, copyrights, and patents, but there are a couple others. So trademarks are, like I said, your brand identifiers. People associate quality, quantity, color, all kinds of things with it. So it's usually your name, your company name, your logo, a product name, things like that. Mm-hmm. Copyrights are the creative content that you have put out there. So a blog post, music, any kind of written work or a photograph you may have taken, anything that stems from your creativity. Mm-hmm. And then patents are inventions. So anything that's new, a new process, so whether that's a new medication, a new app, a new software, things like that, those are all things that you would patent.
Now, is patent, just to clarify, is patent just science?
So it's science-based, yes. So whether it's computer science, medical sciences, it usually falls in that realm because your inventions usually tend to affect those things. Okay. Mm-hmm. There's also something called trade dress and trade secret. So trade dress, a great example of that is like the Apple store. Mm-hmm. When you walk into an Apple store, regardless if you see the apples, you know it's an Apple store. Mm-hmm. Between the glass displays, the all white, and all the other elements that make an Apple store what it is, it's very clear that you've walked into an Apple store. So that kind of packaging, whether it's a storefront, a box, a bag, whatever the product comes in or the service is dressed up in, that is trade dress. So it's kind of an...
Can you just clarify trade dress? Is trade dress like the fact that you see a big Apple sign when you walk in? It's not the layout of the store, right?
Yes, it's the layout of the store. So the Apple sign would be the trademark version of it, right? But when you walk in and Apple looks, there's always the crisp white tables, the equipment sitting out, the shelving in the exact same place, the help center in the back. That look, that design element is the trade dress. And that can also be a box or bag, as I said as well. So it's the packaging of the service or good.
Interesting.
The uniformity of that, yes. So it's kind of an extension of a trademark, right? So your trademark always labels and identifies the brand, the service, the product, right? This is that labeling on the outside in some way.
Interesting.
Yes.
Well, what about for singers? We have some, singers out there. What would they be doing? Would they be doing trademarks, patents? What would it be? So
singers would usually do copyrights, right? Okay. So they've created a song, they've written the words, they've chosen the music to go behind it or written the music to go behind it. That is a work of creativity. So they would need to do copyright protections. Like I said earlier, you don't have to apply with the Copyright Office to get copyright protections, but for something like a song, especially if you're going to put it out there in the atmosphere, you definitely want to get that in Library of Congress. So you want to go to the Copyright Office and you want to apply for registration.
And probably as soon as the song comes out.
Before the song comes out. You want that in your pocket before you put that in someone else's hand, yes.
That's good to know. So how do we acquire the rights of the copyright or the trademark? Go through how we acquire the rights.
Sure. So for a trademark, you have to apply to the USPTO, which is the Patent and Trademark Office. There's an application that you fill out online. And one thing that I will advise everyone is that most applications, about 75%, are denied initially. Do not be discouraged by that. As we talked about before, there are the 5 different categories, right? So if it doesn't fall in that fanciful category, they might make you prove that it falls into one of the others. So they tend to deny, and it's only a temporary denial. They ask you to write an office action response, which is the part where you really need the lawyer, right? So it's kind of a legal brief that explains why your mark would fall into the fanciful, arbitrary, suggestive, or secondary descriptive categories. So be aware that when you get your trademark, if you get that initial denial, it's not that you did anything wrong necessarily, they probably just want more information. So once you've done that and you've responded.
Let's go ahead.
Oh, sorry.
So should a lawyer be the one to actually initially apply, or should you wait for that denial just to save you some money and apply after you've gotten your first denial that you are expecting?
I would recommend you get an attorney from the very beginning because they can prevent you from even getting to that denial. Okay. Based on what the mark is, they know what elections to make or what things to say in that initial application to prove those points beforehand. Sometimes you can't, but sometimes you can. Sometimes you can preempt those questions and get some of that information in there. So you want a lawyer to start from the very beginning to save time especially, right? Because the process is already pretty long. It takes 3 months for somebody to even put their eyes on it when you send in your application. So if you then have an office action sent back to you, that's approximately 6 months that you have to respond. And then after that, you've got to wait for them to take a look at it again. So if you have to get to that step, yes, so it is approximately a year process, especially if you do get that temporary denial, which most people do. But if you can get a lawyer to kind of skip that step for you, it's great because then that cuts the process down drastically.
Interesting. Okay.
So after you've applied and if you had to respond with an office action, and then you get approved, they post it so that people can, object if they have a mark that's similar, if they think that it's going to hurt their brand. So there's a little bit of time for that as well. And then after that, usually nobody responds to that because most people aren't monitoring, other than big companies, aren't monitoring that registry.
Okay.
Then you get your protections, and then you can use the little R symbol next to your trademark.
Interesting.
Yeah. And so for copyrights, like I said, that one's a little bit easier. As soon as it's published, as soon as it's out there, it's copyrighted, you want to put people on notice by using the copyright symbol or the word copyright, your date, and your name. And the date is just the year. And then if you want to apply for the registration, you need to go to the Copyright Office and fill out a similar application to the Trademark Office. And you still want to get a lawyer to do that to make sure all the right information's in there.
Now, you suggest that everyone that does the publishing of copyright also register, right? Or is there certain instances where you don't think you don't have to register?
Yeah, actually there are most instances I think you don't have to register. So if you're doing a blog and you're putting out a lot of continuous content, or if you're tweeting, right? Because a tweet is your own creative thought. I would suggest you put copyright symbol and that whole notice in your bio, but you don't have to register every tweet, right? But when you make bigger things that are going to touch a lot of people, like books and songs and things of that nature, I do recommend that you register with the Copyright Office.
Okay, that's interesting. And what is, just a clarification, what's the difference with the trademark and copyright and trademark? You sort of do it all the same? Like if I have shades of red, I do register my trademark because I have a logo, but then I do the copyright just to protect the information on the website?
Exactly.
Okay.
So the trademark or the brand, right, that shades of red that's going to be in everybody's face, that's your trademark. That's what you're going to trademark and protect with those rights. But your copyright is, it could even be, let's say later you put out marketing materials that's copyrighted. Okay. Your website is copyrighted. Any kind of information that you create or content that you generate would be copyrighted.
Good clarification. Okay. Okay.
And then so to secure a patent, that is a very long and arduous process. You have to submit an application, it gets examined, and then you are granted rights. And that process takes a long and tedious process, and I really recommend that you get a lawyer for that. And you'll need a lawyer who specializes in your area. So if it's a software, you need a patent attorney who has a computer science degree. If it's something in chemical engineering, they need that degree as well as the law degree.
Now, let's clarify that patents applies to those that are inventors, right? Mm-hmm. Those that invent. Let's just say I decide that I have this really cool new phone idea that I have, so I'm going to put it all together, and maybe I might market it to those infomercials. So before then, I should apply for a patent.
Yes. So if you create something new, unfortunately, a phone I would have to see you do something really special to get a patent protection for that. Okay. But it would be more likely that you could get a feature of that phone patented, right? Okay. So if you add some new special chip, some high-speed something, you could get that part patented, and you'd want to definitely do that before you put it out to market. And what patent protection does is it gives you 20 years of protection. And that length of time gives you an opportunity to earn a return on your investment, right? The R&D that went into creating that, you get your money back and make a little profit. But then it opens it up to people to improve upon that, because the whole purpose of patent law is for innovation. So we want to make sure that there's an opportunity for people to add their thoughts and ideas to that and make it better.
And that's a question that I have. So, the first smartphone was probably the Apple iPhone, right? And from there, you see all these different companies starting their own smartphone. How are they able to do that?
So the nice thing about patent protection is it gives you the 20 years, right? But kind of when people see the technology, it spurs ideas in their minds anyway. So as long as they don't copy exactly, they can kind of use that as inspiration to create their own thing. So people tend to do that. So you see iPhone and you're like, ooh, touch screen, ooh, this and that, the home button in the middle. Maybe we don't need a whole lot of buttons, things like that. You can create that for yourself. And as long as you've recreated it for yourself, you haven't copied their process and procedure or copied their elements, then that's okay.
And is it now, if the iPhone, Apple has their own, but then, we have the Android versions, do they patent?
They have theirs patented as well, yes.
Gotcha.
There's been a lot of cases of them going back and forth about who was first and who owns what, but they all do have their own or have sought their own patents for different elements of those phones.
Okay. Mm-hmm. Okay, so we've gone through trademark, copyright, patents. Is there anything else?
No, for the trade dress and trade secrets, those are kind of inherent like copyright, right? As soon as you create them, your job is to protect them and keep them close. So trade dress, you might register it under a trademark if you can get away with it, but other than that, it's just kind of putting people on notice that you own that packaging element. So Apple was able to actually get a trademark for their store, but not everyone can do that with their packaging. And then trade secrets, we actually didn't get to talk about the definition, but a trade secret is kind of that secret sauce, the stuff behind, right? So the secret stuff that makes your brand special, that makes your product special, that makes your service special. So a great example of that is Bush's Baked Beans. They're always talking about their secret family recipe, right? That is their trade secret. Okay. It makes their thing special. So that also is something that you just kind of have to police and protect. Okay.
Well, now let's go, before we close up, let's talk, just say your website so people can know how to get in contact with you. You have, and that, how do the digital counsel, is that where it is?
Yes, so I have a blog called thedigitalcounselor.com. It is a great avenue for you to get more information about intellectual property issues, starting your business, branding, internet issues, and I try to make the information accessible. Join the dialogue, comment. I also do workshops around the area, so please look out for information about that, and that is on The Digital Counselor as well.
Well, thank you for joining us, and thank you for joining us at Chat with the Lawyer. Join us next time.